Hi, everyone. I'm Stacy Cole. I'm here today to talk about the difference context makes in studying the U.S. Southern Claims Commission process, which is going to be our example today. I'm going to turn off my camera so that it's not distracting, and then I will go ahead and start. So, how many of us have found a record involving our ancestors in a historical process? The natural tendency is to evaluate the record for genealogical details and then just move on to the next record. However, in researching the U.S. Southern Claims Commission process in Liberty County, Georgia, I discovered an excellent example of how the context surrounding the record can change our interpretation of it. Not only that, but researching the process and reading the records involving others, not just our ancestor, can add enormously to our understanding of our ancestors' life. So this presentation is about the U.S. Southern Claims Commission process, but it's not only about that. I'm using the Southern Claims Commission process in Liberty County as an example because my research is primarily in Liberty County, Georgia. I have a digital genealogy project called theyhadnames.net that focuses on documenting the names of African Americans in early Liberty County records. So far, we've transcribed over 60 of the SCC claims from Liberty County, and the process of focusing on the community experience has really changed how I see the individual records. Although I'm going to talk about the commission and tell stories from Liberty County, the message I hope you take away from my talk is really to investigate thoroughly not only the historical context of your ancestors' lives, but also to imagine in detail what your ancestor actually experienced as a way to surface anomalies and really understand the record. Here's an example of what I'm talking about. Both the testimony on the left and the right were part of the same process, the Southern Claims Commission process. How differently would you view your ancestor if he or she gave the testimony on the left, which really conveys the personality of the witness, versus the testimony on the right, which does not at all? Yet, is the difference between the two witnesses or between the two people who wrote the testimony down? These testimonies were part of the same process, but they were written down by two different men or women. As we'll see later, that accounts for the difference in the tone of the testimony. Would you have assumed from the testimony on the right that your ancestor was just a man of few words? In fact, it turns out that you could not assume anything about your ancestor from the testimony taken by Henry Way, who took the testimony on the right. But first, let's talk a little about the Southern Claims Commission. After the Civil War, the U.S. government began to consider what it might owe Southerners who had had property confiscated by the U.S. Army. The Southern Claims Commission was created by an act of Congress on March 3, 1871, to determine first whether the applicant had been loyal to the Union, which was a requirement for compensation, and how much should be awarded in compensation. So these were like the Army comes through your town and it takes your horse. But you're loyal to the Union, and so really you feel like the government owes you for that horse. The claims were either allowed, disallowed, or barred. And if they were barred, it meant the applicant wasn't eligible for the program, usually because they were actually loyal Confederates, not loyal to the Union. Overall, there were 22,298 claims, and only 32% of them overall in the whole program were approved. As the name suggests, the program was only in the southern states, so only residents of these 12 southern states could file a claim, and those were Alabama, Arkansas, Florida, Georgia, Louisiana, Mississippi, North Carolina, South Carolina, Tennessee, Texas, Virginia, and West Virginia. But if a resident of one of those states had moved to another state but had had losses in an approved state, they were also able to file claims. So there were actually claims from a total of people living in 24 states. So where do we find these case files? The original records are held at the National Archives and Records Administration, NARA. They've been digitized and they are available on Ancestry.com and Fold 3. Ancestry holds them in 3 different collections. One is a master list of everybody who was involved which includes, fortunately, both claimants and witnesses, and that is indexed. And then there's another list with the a collection that actually has the case files for the people whose claims were approved, and then another for the case files for the people who were disallowed or barred. And I'll show in a minute how to find those. But I have some bad news about them being available online. Some of the case files online are very faded, which you would expect from that long ago. Our plan for my website was to transcribe all of the ones from Liberty County, but some were so faded we couldn't really read them. But I reached out to a professor who had done research on them, and when she gave me her notes, which she had made while she was looking at the originals at NARA, I discovered that she had notes on things I couldn't read on the online files. And so I talked to her, and she confirmed that the digitized copies online are not as legible as the ones at NARA. They're not terribly worse, but enough worse. And I don't say that to discourage anyone from using the online files, which are great. But if you find something that's important for your research that's not legible, you might have to reach out to NARA or to go to NARA to get them. I have had good success, though, with downloading the pages and playing with the light-dark contrast to make them more legible. Sometimes it works. The one I'm showing here for an example wasn't all that bad. To start with, some of them you can really hardly read at all, but this is worth a shot. So the first thing to do is to read about and understand the process. The St. Louis County Library has an excellent set of web pages about this, and the Family Search Wiki, of course, has another excellent guide. The St. Louis County Library is the only place I've found really that has a sets of standard questions that were asked of every claimant and witness. And I was thinking about this today, and the fact that the St. Louis County Library has that is actually an example of my premise, which is that it really matters who's involved in a process, because it's obvious there was someone at the St. Louis County Library who was really interested in this process and took the trouble to put together all this, even though it didn't apply to their local clientele very much. So the set of questions changed over time, and they're often not included in the file, so you really need to have them. I think on the handout, I have a link where you can get to the St. Louis County site, and it's worthwhile downloading the different sets of questions, because it depends which set of questions was used, depends on when your ancestor actually made the claim. So since they did change over time and they're usually not in the file, if you don't have the list of questions, you can't know what number 7 was an answer to. So the questions we just saw were from a set that were used to prove the claimant's loyalty to the union, without which the claim would be denied. The second set of questions here is about how the items claimed were taken, and they really are quite detailed. The case files, which can be found online at Ancestry and Fold 3, and again, they are indexed by both claimants and witnesses. They generally include all the papers that were in the original file, including the original application, any amended applications, the testimony by the claimant and his or her witnesses, which might actually occur several years after the first application was filed, the commission's verdict, which usually has the reasons for their verdict, a special agent report, if any, and if the claim was successful, it will also have the paperwork for generating the award money, because at this time, a lot of people didn't have bank accounts. So in the case of Liberty County, for example, they would send the money to the lawyer, and then we're going to talk about the lawyers later, and they decided at one point that was not a good idea, and they ended up sending the money to the Savannah tax collector, who would bring it over to Liberty County for the successful claimants. The process could take years, and if the verdict was appealed, decades. So this is a little video, I'm going to try to get this to work, of how to find the records on Ancestry. So let me see if I can start this. You will search under the card catalog, and then in the title, just type in Southern Claims Commission, and it will show you the 3 record sets I mentioned, which is the master index, the allowed claims, and disallowed. We'll just click on allowed claims here to get an example, and you can fill in, you could go by last name if you wanted to, but I suggest going by your county of interest. And that should pull up every allowed claim involving a witness or a claimant from that county. And you can see all these are Liberty County. So I'm going to click on one here just to show you what it looks like. And you can see they literally took the manila folders and filmed what was in them. So you'll have the original application. That was actually the commission's verdict. This is the original application with the witnesses they plan to call. And then it goes into what happened when they actually did the testimony. So this is the testimony of the claimant and the witnesses. And then you'll see what appears to be the actual testimony. It's couched that way. My name is such and such, but it's actually, of course, written down by somebody. So what's written down is not necessarily what was said. It's someone else's version of what was said, and how complete that is really depends on the person taking down the testimony. So let me get out of there. So since I'm going to talk about Liberty County, let me set the stage for Liberty County as an example of what kinds of things prompted these claims. When Sherman's army reached Savannah in 1864, late 1864, following their march from Atlanta, they were hungry and they were tired, and their horses and their other stock animals were giving out. So the army turned to Liberty County, which was a wealthy farming community just to the southwest of Savannah. And most of the white planters and slaveholders had fled there. Some had taken their enslaved people with them. Some had left them unsupervised on the plantations. You can see here a present day map showing the location of Liberty County in relation to Savannah. The people who remained on the plantations were right in the path of this army that was foraging for everything it could get. So the Southern Claims Commission testimonies really paint vivid pictures of the encounters between those foraging soldiers and the enslaved population. Liberty County had a relatively high claim rate compared to other Southern counties, and I'll explain why later, and an even higher approval rate, 60% as opposed to the 30-some% overall. Most of the petitioners were African American, and they had a higher rate of success, mostly because the white petitioners had a lot of difficulty proving their loyalty to the Union. I mean, after all, even if a white resident had those sympathies during the Civil War, it wasn't really wise or safe to express them. So it was difficult to prove later because the commission wanted to hear from people you had told that you were loyal to the Union, and there probably wasn't anybody. The Southern Claims Commission was troubled by how many claims came out of Liberty County. We'll discuss later, many of the claims appeared to them to be suspiciously similar, and they thought exaggerated. And we'll discuss why that was and how much of it might have been true and how much of it we can attribute to the racism of all the parties involved, which we'll discuss in a minute too. So I mentioned that I have a website called They Had Names, where I post abstracts and transcripts of documents naming African Americans in early Liberty County records. The site has so far posted more than 60 full transcripts of these case files, and I've posted research on more than 40 of the claimants, tracing their lives back into slavery and forward into freedom. Kathy Dillon, who's a wonderful person who did many of the transcripts for the site as a volunteer, transcribed many of these claims. So reading all these claims and researching them is how my view of the process came to change, because I originally just took everything at face value. It wasn't until I began to try to imagine the details of how the process played out for everyone involved that I realized how much human interactions, animosities left over from the war, and just good old human frailties affected the outcomes. You might be wondering why enslaved people had property to take. The property taken by the soldiers from the enslaved people consisted mostly of cows and hogs, rice, corn, and potatoes, sometimes honey, and occasionally a horse and buggy. Oops. In Liberty County, most slave owners used the task system, in which an enslaved field hand would be assigned a certain amount of work, and if he or she finished that work before the end of the day, the rest of the day could be used to raise stock, plant crops on unused land, etc. Often the arrangement was that the enslaved person would sell the produce or meat to the slave owner or on the market. Now, this practice was not necessarily a kindness by the slave owner. It had multiple advantages for the slave owner, including tying the enslaved person to the land to discourage running away, and also because then the slave owner didn't have to supervise the process by which all of that extra food, etc., was raised. For a more detailed discussion of the complicated background to this practice in Liberty County, I've linked in the handout to a couple excellent articles on the subject. The task system, though, is why there were more formerly enslaved people filing claims in Liberty County than in other counties, because they had property that could be and was taken. However, I'll also discuss in a minute another factor, because of course other coastal counties used the task system as well. As you can imagine, given the time and place, the claims commissioners struggled in particular throughout the program with whether or not slaves could be considered to have owned property, since actually they were considered to be property. In a convoluted piece of logic, they sometimes reasoned that any property, especially food, that was owned by an enslaved person would have had to be supplied by the slave owner anyway. And so thus it was not only actually the property of the slave owner, but it actually aided the Confederate effort. One of the lawyers for the claimants had a dry and successful response, which was to say that this property belonged to the master and therefore should not be paid for does not look very well from the high moral anti-slavery standpoint, which of course it did not. The commission came to accept that enslaved people in Liberty County had owned property, and in fact, that this property was often used to supplement what was provided and as luxuries, quote unquote. Drivers were enslaved people who were assigned a supervisor position on the plantation. They had particular opportunities to obtain property, and so they were overrepresented in the Southern Claims Commission petitions compared to others. The Southern Claims Commissioners originally misunderstood those opportunities, and they thought that a supervisor who did not work the fields himself would not have a chance to own property. However, it was just the opposite. There were many testimonies that the drivers were able to have other enslaved people tend to their property and that they received special privileges. So what if your ancestor was the one who received the verdict at the top left? Would you have enough context to know that this verdict was actually based on a misunderstanding? Enslaved people in Liberty County considered themselves freed once the U.S. soldiers showed up and told them they were free. The Army stripped the county of everything there was to eat and any animal who could provide transportation. It left the remaining white planter families in a state of helpless rage and fear that honestly people are still holding grudges about to this day. The now freed people, as you can imagine, had a very different reaction. After the first shock and fear, many of the African-American claimants described going to the soldiers' camps to cook or do laundry for them. It was December, and John Bacon testified that it was cold, and he felt like the soldiers needed things like blankets and quilts. Many of the African-American claimants freely gave the soldiers what little food they had. When Kathy and I started transcribing the case files for Liberty County, I really just paid attention to the testimony and the verdict. The more we did, though, and the more I researched the claimants, the more I saw the overall process and realized how easy it would be to misinterpret something if I read only one claim because, for example, my ancestor was in it. As we all know, of course, the post-war period was very complicated and many societal forces were combining in this one seemingly simple application process. There was a deep racism permeating all aspects of the process, as we'll see, and also a more subtle sense of class. Although well-off white claimants were likely to be denied their claims because of a presumption that they had been Confederate sympathizers. Their testimony was actually sought after by the special agents who were investigating claims, and often a case would be denied simply because a prominent white man commented disparagingly about his idea of the character of a formerly enslaved or lower class white claimant. So we'll discuss later how the commissioners came to their decisions on the cases, but it's important to remember that this process took place over time and the commission's views changed over time and also were not consistent over time. So let's start with the lawyers because that's where it all started. It appears to me, though I can't be sure, that one of the reasons Liberty County had such a high number of claimants in addition to the task system was this first lawyer we're going to discuss, James M. Sims of Savannah. Reverend Sims of Savannah was probably the first lawyer to have contact with the Liberty County freed people to help them apply for the Southern Claims Commission program. As you can see in the bio here, he was born into slavery. He was punished in Savannah for teaching people to read and write white. He was a deacon of a very prominent church in Savannah, joined the Union Army, a very prominent man. On September 14th, 1872, he went to Liberty County and he brought together the first African-American applicants to write their applications, which required them to declare their loyalty to the United States, enumerate the property they had lost to the soldiers, and declare the names of their witnesses. The loyalty part was mostly just a formality. The commission assumed that formerly enslaved people had wanted the Union to win. So remember that Reverend Sims was able to read and write. Almost all of the Liberty County African-American claimants were illiterate. This would become a point of dispute. Many of the applications he wrote were believed to have exaggerated the amounts and values of the confiscated property. At least one claimant later denied signing the initial application, and others said in their testimony that what Reverend Sims wrote down for them was not what they had told him. Now, there's no doubt in my mind that he did it in order to help them. I can't see any other motive, and God knows they were entitled to it. But it did end up hurting some of the claimants whose claims were denied because of it. However, it does appear to me that many of the successful claimants owe the fact that they made claims at all to James Sims. So that day, September 14th, 1872, I am the descendant of Liberty County slave owners. That was my primary motivation for starting the They Had Names website. My second great-grandfather, Joseph Ashmore, was the Liberty County probate judge, the ordinary, from 1876 to 1889. So I'm used to seeing my maiden name on Liberty County court records, lots of relatives in the court system, but I was not expecting to see it in the Southern Claims Commission records. When James Sims brought together those claimants on September 14th, they must have used the same pen for all of the applications written that day, and those documents have faded much more than many of the other documents in the case files. So it took a while before I noticed that it was my second great-grandfather who was the witness for all of those applications. His nephew, John S. Ashmore, was the other witness. In this claim, I had enhanced this one, and you can just barely see it. So they were witnesses to the scene that day, and I would love to find somewhere where they made an account of it, but of course I haven't found it. These are their signatures on Titus Alvin's application. This is one of the good ones, and it's the one where I finally realized that their names were there. Oops. So the next lawyer, Reverend Sims, was involved at the beginning, and then this lawyer, Raymond K. Jr., came to be much more involved. He was the son of Raymond K. Sr., who was a land and slave owner in Liberty County. Raymond K. Jr. took on a number of these petitions by freed people, but he was eventually barred from receiving awards on their behalf by the Claims Commission, which in 1877 called his abuse of his clients the most flagrant case they had seen, and they met across the South. He protested that his terms to his clients, under which he took half the award plus double the special commissioner's fee and the other fees. So leaving his destitute clients with little of the original award money. He said it was fair because he was the only white lawyer who would take these cases from African American clients. He said that James Sims and W.H. Sykes, both African American lawyers from Savannah, wouldn't advance their own money to pay the fees like he would, leaving out, of course, that he was in a completely different financial position than they were. The Treasury Department rejected his explanations and finally assigned the task of delivering the awards to James Atkins, who was the Savannah Port Customs collector, and he traveled to Liberty County and did it in person. Another important factor that I wouldn't have considered before taking on this project is that it mattered who the special commissioner overseeing the case was. There was one special commissioner at a time, and they were appointed by the commissioner to take testimony in cases where the claimants could not travel to Washington to be heard before the commission itself. And that was the case for most of the really poor Liberty County claimants. In fact, I don't believe any of them traveled to Washington. For these Liberty County claims, the change in special commissioners over time was highly significant. As I mentioned, there was only one at a time. The first one was Virgil Hillier. He moved from the north to Camden County, Georgia after the Civil War, was considered a carpetbagger. He was elected to the Georgia State Legislature, but lost his seat in 1871. So why does his history matter for these Liberty County claims? Because when he took the testimony of these formerly enslaved claimants, they were speaking to a Northerner who, even though he probably had all of the prejudices of his time, he could be presumed by them to be sympathetic to them. And how can I assume that he might have been sympathetic beyond the obvious fact of being a Northerner? When I was reading the testimonies that he took, I had wondered if he actually wrote down the testimonies himself. They are really vivid and detailed, and they sound like they're the claimant's own words. I started noticing that an E.E. Adlington was acting as a witness, which is a surname I don't recognize from Liberty County. Well, it turned out that E.E. Adlington was Ellen Adlington, and she was one of those school teachers who came from the Northeast, in her case, Massachusetts, to teach in the freedmen's schools. So I think she was the one who took down the testimony, and that between the two of them, the freedmen felt more comfortable speaking their truths in their testimony. This is where these testimonies are where the testimonies critical of the slave owners come from, even though even then, the claimants most often make those criticisms of other slave owners. You know, theirs was a good guy, but these other guys were bad. Because remember, no matter who was taking the testimony down, the lawyer in the room for most of this was Raymond K. Jr., son of a well-connected Liberty County slave owner, who would most likely repeat what was said to others. So Hillier was also not free from criticism when the commission accused Raymond K. Jr. of charging double the special commissioner's fee. And it noted that if this was true, the special commissioner was also unreasonably enriching himself by taking a fee, and it was Hillier they were talking about. He was not supposed to be collecting a fee. He was paid by the commission. Henry Way, the next special commissioner, was a very different man. For one thing, he himself was a Liberty County native and a former slave owner. He had extensive family connections within Liberty County, and he was the clerk of the Liberty County Superior Court when he was named as special commissioner. In fact, that appears to be the reason he was named the special commissioner, because his successor also held that position. We can imagine that it was a very different thing as a formerly enslaved person to testify in front of Henry Way. In fact, one of the early claimants, while Virgil Hillier had been special commissioner, actually had been held in slavery by Henry Way. Prince Stevens testified in 1873 that he had had nothing to do with Henry Way since December 1864. He also added, thank goodness, that Way had 5 or 6 enslaved people who were 2 families. So that's a really nice genealogical note for any of their descendants. The image on this slide shows Prince Stevens being used as collateral on a promissory note by Henry Way to Joseph R. Bacon. prior to the war, of course, is it likely that formerly enslaved people would speak freely in front of him? So there was a third commissioner for a brief period, J. Sloman Ashmore. He was also the clerk of the Liberty County Superior Court, which helped me understand that was one of the criteria for choosing the special commissioners. He was a former Confederate soldier, having been chaplain of the Georgia 25th Infantry Regiment at the end of the war. He was also my second great-grandfather, Joseph Ashmore's eldest son, and he inherited the probate court judge position from him later on. Again, not an easy person for formerly enslaved claimants and witnesses to testify in front of. So now we're back to the slide we saw at the beginning with the two very different styles of testimony. And now you can see the dramatic difference it takes. It matters who took the testimony. The testimony taken by Virgil Hillier on the left there, it sounds like natural speech and it was descriptive. You almost felt like you were there at the scene. The testimony taken by Henry Way on the right sounded robotic, and it was clearly just notes taken down by someone. I think it was taken by Robert Quarterman Castles, who had a store at the railway stop and who acted as the claimant's counsel, in quotes, under Henry Way. So imagine that scene. You're testifying in front of former slave owner Henry Way and white merchant Robert Q. Castles and whoever else might be shopping in the store. If your ancestor was a claimant or a witness in testimony taken by Virgil Hillier, you've gotten lucky. You would really get a feel for how they spoke, details about their lives, even their emotions about the Civil War. If you only saw the testimony taken by Henry Way or J. Sloman Ashmore, you would have a completely different experience, just as the claimants and witnesses probably did. It is likely not only that there was a difference in what the note taker chose to write down, depending on which special commissioner was there, but also what the claimants and witnesses chose to say. The Southern Claims Commission noticed the difference too, and it made frequent complaints about the lack of detail in the testimony taken by Way. They were obviously suspicious of Robert Q. Castles, whom they described as an attorney, but he probably was not. After reading all the claims that Way and Castles did, I'm also suspicious. I think some of them were made up. I'll discuss why they might have done that later. There were two special agents seen so far in this Southern Claims process for Liberty County, R.B. Avery and W.W. Payne. They lived outside the area and would be sent in when, as often happened, the commission had doubts about a case and needed more information before making a decision. The special agent report for each case is included in the case file. The reports reveal what was a very obvious bias on the part of the commission for white witnesses who were prominent members of the community, so both race and class involved, though they did consult certain African American members of the community whose testimony was kept private. Claims in which only formerly enslaved people were witnesses, and especially if their testimony was taken by Henry Way and R.Q. Castles, so there was very little detail, those claims were likely to be rejected out of hand. If there seemed some doubt, the special agent would be sent. He would interview Liberty County residents as to the character of the claimant and whether they knew he or she had owned property before the war, and if he could, he would even visit their homes. So you can imagine those special agent reports make for fascinating reading, but the bias is very clear and you have to take it into account when you're evaluating them. So the commission constantly struggled with how to value the property that was confiscated from formerly enslaved claimants. They felt pretty comfortable with valuing the property of white people, but it was considered, and in their eyes confirmed by white former slave owners, that the property owned by enslaved people was inferior in quality to that owned by whites, particularly when it came to horses and buggies. So finally, the special agent came up with this list that was used in making the monetary awards, though of course it bears no relationship to the property actually owned by any one individual. When George Powell submitted his claim in 1878, the special commissioner was Henry Way, a former Liberty County slave owner who took very sparse and suspiciously similar sounding testimony from the claimants. A number of the claims processed by Henry Way, of course, as I said, were denied on the grounds that the claimants provided no details about how they had obtained the property. Powell's claim was no different. He provided no details at all. So why was his claim approved when others were not? His white former slave owner testified for him. In other such cases, the former slave owner was either dead or had left the county, and those claims were mostly denied. So more than a decade after the Civil War ended, Powell still needed the testimony of his former slave owner, a man who might be hostile, dead, or just absent, to win his case, even though it was well documented that enslaved people in Liberty County had owned property and that this property had been taken by U.S. soldiers for Army use, which was a criteria, during the raid on Liberty County. Powell received $86 of his $220 claim. The Southern Claims Commission was much more likely to approve a claim if the formerly enslaved claimant had at least one white witness, preferably a former slave owner, who would say that he knew that the claimant owned property. So evidently aware of this, the lawyers enlisted the services of several young white witnesses who were the children of slave owners who would swear that they knew that the claimant owned property. The commission would sometimes accept this, and sometimes they would point out that the witness would actually have been a child during the Civil War. The special agent would make it a point to seek out prominent white members of the community on his visits to Liberty County to research cases, and he put a lot of weight on their word, and so did the commission, both as to the character of the claimant, meaning whether he was likely to have been industrious enough, that was a word they used a lot, to have really owned property, and to the value of the property. So it was very common for even an approved claim to have the amount significantly downgraded because a white witness cast doubt on the value of enslaved people's property. This isn't surprising for the time period, but if you were only reading one claim, it might be able to overlook this as a factor in either the rejection of the claim or the downgrading of the amount. So common reasons for denying a claim. The testimony was so weak as to not overcome the presumption that the property belonged to the master and not to the slave, and that sometimes the testimony actually was very weak, say in the ones taken by Henry Way. Sometimes it was more the commission's own preconceived notions of this that were the problem. The belief, again, that the property was so meager that it must have been stolen for the soldier's own use. If a soldier stole your property for his own use, you were out of luck. It had to have been stolen for the Army's use. Because they didn't have white witnesses, Samuel Osgood's claim would have been denied, but it just happened his former slave owner was visiting from Thomas County and agreed to testify. The age of the claimant, if they thought you were too young before the Civil War to have owned property, which does make sense. And the ownership of the property not proven. And again, this most commonly happened in those testimonies that were taken by Henry Way, where he just either didn't ask the questions in a way to elicit details or didn't write down the details. So some questions to ask yourself while reading the claim. We've covered the ways in which the process and the participants in the process are important to research as you're looking for your own relative's part in the Southern Claims process or any process. So here are some useful questions to ask yourself while reading a claim, which also illustrate the kinds of detailed questions you should ask yourself when examining any document involving your ancestor. Where was the claimant living? The testimony and the application here will both tell where the person lived at the time the property was confiscated and where they were living at the time of the testimony. If those two places are different, that gives you a clue that your ancestor moved. Also, the application, as I mentioned, might be taken several years before the testimony was actually taken, so you might have two different locations listed then. Who were the witnesses to the signing of the initial application, and did they testify? If they didn't testify, well, given that some time had passed, these people would have been close associates of the claimant. Maybe they had died or moved. And so if the person you're researching is actually one of those, and I'm sorry, that's not the right note there. But just pretend that says where was the claimant living. So you do want to note the person that you're looking for, if either their location changed or if the time had passed and they didn't testify. What does that tell you? Is it possible that they died? So is the surname of the claimant the same as the surname of the slave owner? That was not necessarily, it could mean that the person had been held in slavery by the slave owner, and that is a presumption that you do want to investigate. I have found cases, though, where they were the same surname, and I've been able to show that actually the person was held in slavery by a different family with that same surname. So it doesn't necessarily mean what it appears to mean, but it could. So, and here's who were the witnesses to the signing of the initial application, and did they testify, and what does it mean if they didn't testify? Did a witness testify in more than one claim? And that could be, I have noticed that some people testified in a lot of claims. And now that could be because they were a lot of the people were concentrated in the area of Sandy Run Road. So it could just be a coincidence. It could also be that some people were more available to give testimony than others were. So it's something worth looking at. If your ancestor testified in one claim, be sure to look and see if they might have testified in other claims, because they might give additional details about their lives. So who was the special commissioner in the case and who was the lawyer? As we've discussed, investigating those people may shed clues on why your ancestor's testimony appeared terse or why it might be focused in certain ways, such as not blaming slave owners if you're testifying in front of a former slave owner. And then are there people mentioned other than the claimants and witnesses? And those people will not be indexed. So that's a good reason for reading all the claims from the county you're interested in, because one of the questions is, who else was present when the property was taken? And those names aren't indexed, so though they might list 6 or 7 people, and one of them might be your ancestor. So we've covered all the ways in which the process and the participants in the process are important to research as you're looking for your own relative's part in the Southern Claims process or any process. So here are some useful questions to ask yourself. Oops, I'm sorry. Moving on to the next slide. Because the claims process was only for people who could claim and could prove that they had been loyal to the Union, the claims surface stories that often aren't told. So one of them was of Elizabeth Summersall and her 2 sons, John and James. They were poor, they owned a few acres of land, they grew their own food, they milked their own cows, and they didn't own people. When the Civil War started to appear on the horizon, Elizabeth, who was a widow, started telling the neighbors that they shouldn't fight to keep their slaves. John had to tell her to stop, or she was going to get him killed defending her. She did stop. When the war actually started, John knew he was going to be expected to sign up to fight. He didn't want to. How do we know that? From his mother's Southern Claims Commission petition. She called on 3 formerly enslaved men, Sam Elliott, Moke Todd, and Lafayette de la Gaulle, to testify for her. Sam Elliott walked 15 miles each way to testify for her in August, at a time when he should have been weeding his crop. He said he did it out of kindness. He testified, if I should go to her house now, she would set me at her table just the same as herself. Sam said in his testimony that John came to him on the plantation where he lived at the beginning of the war and asked him to take a hatchet and cut off some of his fingers so he wouldn't have to fight. Sam wouldn't do it. John and James were forced to sign up at the end of October 1864. As Sherman's army approached Savannah, James was sick in a Savannah hospital. He and John deserted and went home to Liberty County to hide in the woods, where one of his mother's witnesses said he used to bring them food. Elizabeth wanted him to hide James, who was still so ill, but he wouldn't do it because he said he had known some slaves who were whipped nearly to death for harboring a deserter, and that was as bad as shooting would not hurt so bad. Lafayette, another formerly enslaved man who testified for him, said They were poor men. They owned nothing but horses and cows and such things. They could not go in a rich man's home in Liberty County. John and James died not long after the war. Elizabeth lived to be 84. When she died, she gave her house and the surrounding lot to a much younger sea captain who lived with her, and she gave a 10-acre plot of land to a 62-year-old African-American widow, Matilda McIntosh, a formerly enslaved woman who had cared for her. So why read documents that didn't involve your ancestor? Well, your ancestor may have been in a similar position to the Summersalls, but didn't make a claim. Or this might provide a window to a different kind of life in that place and time that helps you imagine your own ancestor's life, either in contrast or because it might have been similar. Although there was little testimony about the personal interactions between the formerly enslaved people and the soldiers, the testimonies were very clear that they were overjoyed to see them once the soldiers told them they were free. Jack Walker was disappointed at the loss of his property. He said he cried like a child when he saw all his things taken, and he personally complained to Colonel Atkins in charge of the soldiers, which I just think is amazingly brave. But John Bacon's reaction was more usual. He said, "I had rather have my freedom than any horse, glory to God." Putting these reactions together, even if only one of them involves your ancestor, helps you understand whether your ancestor's reaction was a universal one or not. So at the end of the Civil War, Prince Stevens was an enslaved man in his 30s who could not read or write. By the time he died in 1908, he owned more than 500 acres of land. What else might have happened in the post-war lives of these claimants? Jack Wilson's story is one that illustrates the usefulness of the Southern Claims Commission files for genealogical research. He testified in 1873 that he had been held in slavery on George W. Walthire's Westfield plantation. He also said that he was currently living on and renting property belonging to John L. Hardin, who was a member of the White LeConte family. In the 1870 census, he is seen living with his wife Dinah and working as a farm laborer. However, by 1875, he had bought land from Joseph Ashmore, my second great-grandfather, which is another unexpected connection for me. By 1910, Jack and Dinah, or now Diana, have been married for 48 years and have had 11 children, 9 still living. And one day, while I was looking through the First African Baptist Church in Riceboro Cemetery, I found his headstone. It's the only headstone I've found for an SEC claimant in Liberty County. He had a Mason symbol on the headstone. Unfortunately, his son Jack died in 1929 of a gunshot wound, but the death certificate told me that Jack's wife Dinah's maiden name was LeCount, so she was likely enslaved by the LeCount family, and this was the reason that they had been renting land from John L. Hardin, who was married into that family. Aberdeen LeCount filed a Southern Claims Commission petition naming his last enslaver as William LeCount. Aberdeen showed up in William LeCount's 1841 estate inventories. In these estate inventories, I have often found people listed in what appears to be family order. Here you can see that Prince, valued at $500, and Suki, valued at $400, could very well be the parents of Charity, Aberdeen, Katie, and Bristol, listed in descending order of value that probably indicates age, while Hamlet, valued at $500, appears to start a new family group. William LeCount's father, Louis LeCount, had an 1838 estate inventory that also shows these individuals in the same order, with Bristol likely born between 1838 and 1841. In the 1870 census, we see Prime and Suki LeCount living in the same household and presumably man and wife. So the Southern Claims Commission testimonies always name the former slave owner, which is a godsend to anyone trying to break through the 1870 brick wall to find information about their enslaved ancestor from before the Civil War. Having a list of all the claimants and witnesses with the former slave owners' names would be so extremely helpful, but it would be a mammoth task. Fortunately, for everyone interested in this history, Dr. Peggy Hargis, a retired associate professor from Georgia Southern University, had already compiled this list, and that's what it looked like at the Dorchester Academy African American Museum in Liberty County in a remarkable exhibit that she created. So I took pictures of it, and then I contacted her, and she actually gave me permission to put it into a spreadsheet, a sortable spreadsheet that is on the website. It has 275 or so people named in the list. And from this, we know that only about 10% of the people who named their slave owner took the surname of the last enslaver. And that sent my direction in a research that now confirms that is the case. It was actually quite uncommon for someone to take the surname of the last enslaver. So context matters. Research both the broader historical context and, as much as you can, what was going on in your ancestor's immediate environment. Research the details of any process he or she was involved in. Imagine your ancestor going through whatever process it was as if it was in a play. What did the room look like? Who was in the room? Why did it matter who was in the room? In the case of the primarily freed people and the poor white people who made these SCC claims in Liberty County, it probably mattered whether the people in the room were from the former enslaver ruling elite or from the North, whatever their own biases might have been. What was the weather likely to have been that day? Who wrote down the testimony? How did that person's level of education affect the way your ancestor sounds in the testimony? Was your ancestor illiterate? If so, do you need to worry that they may not actually have known what was submitted in their name? It might be false. Research everyone involved. You'll find out some surprising details that probably affect your research, such as new relationships, and you'll get some great stories. Finally, putting the details into the story will make it far more interesting to your relatives and descendants. You can tell a much better story that way. And so I'll end there and ask if there's any questions. I'm going to end the slideshow and stop sharing.
Thank you so much.
And start the video again.
Thank you.
That was very interesting.